Good evening to you, and welcome to session 11 of our free law school entrance examination revision tutorial. So we invoke the assistance of God as we start. Heavenly Father, we thank you for the gift of knowledge and opportunity to prepare for this important journey. Grant us clarity of mind, diligence in study, and humility to learn. Bless our discussions tonight, that they may sharpen our understanding and guide us toward wisdom. We entrust our efforts into your hands, knowing that success comes from you. Amen. Yeah, so we are going to do a discussion of questions and answers, and most of the questions and answers are based upon our revision of the remedies that we did in law of contracts. So this is what we are going to do. I provide the question, and then I give just a minute or two for you to put your thoughts together. And then I will go and walk you through what is expected of you in the question. So maybe the first one we discuss together, and then the next one we will give you the opportunity to make an input. So if you want to speak, just raise up your hand. Only one person should speak at a time. So assuming you have a question like this, and most of the questions I'm providing here are questions which have been examination questions in law of contract before. So the main object of damages for breach of contract is to put the claimant, so far as money can do it, in the same situation as if the contract had been performed. Explain how this principle operates in practice and discuss any exception that there may be to it. So that is the question. So just put a few points down. And then it's a very straightforward question. So I expect all of you to do well. Okay, anybody? Anybody wants to share his or her thoughts with us before we discuss at the group? No hand up. Okay, if you're not talking, let me move on. So the question like this is pretty straightforward. And what I'm saying applies not only to this question, assuming you get any question, be it in contract or any other area of the law, where a quotation is, for example, provided, and there's a follow-up question. So first, understand the quotation. And the quotation provides the context or the background or the backdrop to the question. So your discussion should be within the context of that the quotation, within, of course, the rubric or the question task master. So here, explain how this principle operates in practice and discuss any exception that there may be to it. So you'll be told the aim of awarding damages for breach of contract. And the question is asking you, in a sense, uh, is that the case? Is that the position of the law? If that is the position of the law, are there any exceptions to it, as it were? So, I mean, very straightforward. So, your answer guide, we expect to first, you state You start with the principle. You explain what damages are, and you've explained that damages refer to the monetary compensation awarded for damage arising from the breach of contract. So the loss or danger arising from the breach of contract. So that is damages. That is monetary compensation. And we are reminded in the case law Robinson and Hammond that the aim of awarding damages is not to punish the innocent party, but to put the innocent party in a position that he or she have been in had the contract be performed. So step two, explain different interest damage, different interest damages may protect. So yesterday so when we had a revision on remedies for breach of contract, we did talk about expectation damages, reliance damages, and restitution damage. And again, give practical illustrations with case law, and also discuss exceptions or any qualification to the general principle. So we talk about the remoteness of damages, mitigation of damages, and then the fact that damages will also be awarded in some cases for non-pecuniary or non-financial loss like disappointments and so on. Then the distinction between liquidated damages and penalty clause. And the distinction between liquidated damages and penalty clause also reinforce the aim of awarding damages, which have been articulated in the case of Robinson and Harman. And finally, you pull everything together and you have your conclusion. So that should be the structure which you should follow. So maybe let's work through a little bit more. So we said that you have to state like the general rule that damages in contract are compensatory, not punitive. We talk about that, and that is to say that it seeks to place the innocent party, the claimant or the plaintiff, in the same financial position as if the contract had been performed. Now, if both parties had performed the contract, certainly both parties will have obtained whatever they sought to achieve by entering into the contract. So that if one party does not perform it, what it means is that you'll not be able to realize what you have obtained from the contract. And that is why in making the other party pay compensation, we have to let him pay compensation, which will bring you to the level which you have been if he had actually performed the contract. So in that regard, as we noted yesterday, we are not punishing the contract breaker for breaking the contract. We are only trying to adjust the equation or ensure that each party is taken to where he or she have been if the contract have been performed. We said in Pareto law of Ghanaian cases, the Delta Food case, Mola and the Home Finance Company Limited, so many cases, the same principle have been articulated. And of course, if you look at the rationale behind the principle in Hadley and Baxendale, it comes to the same point. When we say that damages must reflect foreseeable loss, the fact that compensation should be for losses which at the time the parties were making the contract could have been anticipated that it will emanate from the breach of the contract. And as we saw yesterday, that could be one of two kinds, either arising naturally or by reason of special information or knowledge which the other party had been given. He ought to have foreseen that if there was a breach, apart from ordinary losses, some special losses will also have been incurred. So we talk about that. So all this will have to be stated briefly. So we say practical application. The fact that expectation damages protects the benefit of the bargain, what you expected to have obtained from the contract. So maybe the profits that you have lost or the difference between the contract price and the market price as we saw yesterday. And again, you also talk about reliance damage. That is, we said that it covered the wasted expenditure where profits are uncertain. We cited the case of Anglo Television against Reed, the TV series where the actor decided to pull out and then the show could not come on. Some expenses have been incurred in trying to put the show together. Eventually, when he was sued, the court was not in a position to actually assess how much profit would have been made if the show had actually been produced and aired on the television. That could not be ascertained. However, the expenses which have been incurred towards production of the show could be ascertained. So the court awarded damages to actually cover that. So that was the reliance damages, losses incurred in trying to carry out the contractual arrangement which the other party had actually breached. Then we also said that in rare situation where you cannot actually apply expectation damage or reliance damage. However, somebody has been given some value or some benefit under the contract. Another party has not received anything. In order to avoid what we call unjust enrichment, the court may allow some damages to be awarded in order to avoid one party unjustly enriching himself at the expense of the other. So that's what we call the restitutionary damages as the case may be. So let us keep that in mind. We cited Attorney General against Blake. Now, what are the exceptions or what are some of the if you like, the caveat or the qualification to the general statement that we made that the aim of damages in Robinson Harman is that the aim of awarding damages for breach of contract is not to punish the contract breaker, but to put the claimant or the innocent party in a position that he or she would have been had the contract been performed. Yes, there are some qualifications. One is the principle of remoteness of damages. And as we saw yesterday, the damages must not be too remote. In other words, you'll be awarded compensation for losses which are emanating or arising naturally, right, directly from the breach of the contract or within reasonable contemplation. And a reasonable contemplation, we said, is like the second limb of the principle of Hadley and Baxendale that, as Lord Asquith explained in Victoria Land Against Human, that if you have been given an actual knowledge, okay, of a particular thing, then because of the actual knowledge that you have been given, if there is a breach, it will be expected that you have known or you have been in a position to contemplate or to anticipate that a particular special kind of losses will also be suffered by the innocent party. Now, if you are not be given that information, you could not have been in a position to actually contemplate that. So those are what we call like the special damages we mentioned yesterday. Again, the principle of mitigation, yesterday we talked about it. So what we are doing is basically trying to say that you need to summarize most of the things that we said in order to provide an answer to this particular question. So the duty to mitigate, that the law expects the innocent party to take reasonable parties to minimize or reduce losses, following upon the breach of the contract by the contract breaker. If the scale of losses can be contained by taking reasonable measures, which are not too burdensome, then you as the innocent party, you are not supposed to just stand aloof or unconcerned. If you did that, the court will actually reduce the quantum of damages which have been awarded to you due to your unreasonable posture. Then we also talk about the fact that in recent times, the case law jurisprudence revealed that even in law of contracts, when there has been a breach, the courts have demonstrated willingness to award compensation for non-pecuniary losses. That is non-financial losses. Typically, like we mentioned, the Jarvis against Wanto, somebody bought a holiday package from travel and tour operator company, and they'll be giving a certain description, like how the tour experience is going to be. Eventually, when you go to the holiday destination, what was there was different from the description in the holiday brochure or the package. And the court said that there had been some disappointment because what he had expected to enjoy was far less than what he had made to believe. So he was entitled to be given some compensation for the disappointment. Of course, disappointment is not a financial loss, it's a non-pecuniary loss. But the court demonstrated in Jarvis against Wantos that it could, in appropriate cases, award such damages. And of course, we also talk about the loss of amenities. Rosary Electronic and Faucet, if you remember, somebody entered the contract with a strict specification for construction to be done. The construction was done, but not according to the strict specification. And what had actually been constructed could function or could, for all utilitarian purpose, serve the same purpose if the construction had been done according to the strict specification or dimension. That notwithstanding, the court said that by not doing exactly according to the specification, the owner of the project had actually lost a certain intrinsic satisfaction, loss of amenity, by not getting what he bargained for. So he supposed to be giving some damages for loss of amenity. And of course, we also mentioned that St. Smith against KLM, we talked about the air ticket, which was actually could not be implemented as agreed, and the person sought to sue for businesses he was going to sign in Belgium, and the court said that no, you'll not be allowed, but for inconveniences that you have suffered, you'll be allowed to recover some damage. Those are all non-pecuniary losses, and they are recoverable under the current trend of the case law. Of course, nominal damages, we made the point that where there's been a breach of contract and no discernible loss or no actual loss has actually been suffered, but just to vindicate or ventilate the principle that whenever there's a breach, damages should be awarded. Symbolic or a token damages should be awarded, and that's what we call the nominal damages. We talk about speculative damages, but not really important. Now, finally, liquidated damages against penalty clause must also be touched on in order to provide a complete answer to the question. So liquidated damages, as we know, is where the parties to the contract have made pre-estimate of how much loss will be suffered or occasioned in the event of a breach. So when there has been a breach, the parties have already made provision regarding how much compensation should be paid for the breach. So those are what we call the liquidated damages. And then we have a penalty clause. Penalty clause is where, in an attempt by the parties to make the pre-estimate, what they end up doing does not actually satisfy the principle of awarding damages in contract. That is, to put the innocent party in a party that would have been had the contract not been breached. So it's not like a genuine pre-estimate. So in the case of Dunlop pneumatic tires, against the new garage motors, Lord Dunedin laid down important criteria. He said that where there's a stipulation of money to be paid in the contract and the amount stipulated is so excessive, having regard to, if you like, the maximum loss that will have been suffered in the event of a breach of a particular term, then that is a red flag. And again, where the same amount of money is stated to be paid in the event of a breach of obligations, and especially so when the obligations under the contract are not of the same importance, are not of the same nature. Some may be severe, some may be minor, and so on. But if the same amount, if a uniform amount of money is prescribed to be paid for every breach, then it raises a red flag, and it will not really come out as being a genuine pre-estimate of the loss to be suffered in the event of a breach by one of the parties. So the court will strike it down as being a penalty clause, because the penalty clause are seen as being an amount of money to be paid in terrorem, that is to terrorize or to intimidate the other party to perform the contract at all costs. A contract should never be performed unwillingly. If you enter into a contract and you don't want to perform, you know the consequences. You'll be made to pay money by way of damages to bring the innocent party to the position that he or she will be in if you have performed. So, under no circumstance should you be bullied to perform the contract at all costs. So, where you have like a penalty clause, along the lines that I have explained within the meaning of Lord Dunedin's, approach in the Dunlop against the New Garage Motor Company, then that would actually defeat the original aim of awarding damages, and that will not be enforced or upheld by the court. So let's look at that. So the bottom line is that genuine pre-estimates are enforceable as liquidated damages. Penalty clauses are unenforceable. So that is the bottom line. So when you have done all this, then you have your conclusion where you bring everything together, make the point that the principle stated in the Robinson and Hammond works well in practice, but there are some exceptions, or there are some qualifications. And as we have seen, and the fact that, yes, damages remain subject to the principle of remoteness of damages, mitigation of damages, and also there are limits on recovery of non-pecuniary losses. Not all financial losses can actually be recovered. So that one also need to be appreciated. Yeah, so that's a very straightforward question. Let's move on to another question. Um, how do the court decide whether to grant another for another specific performance? This has also been like a past question in my contract exam before. Are the criteria used sensible? Very straightforward question. Will somebody attempt an answer for us? Anybody?
Hello, sir.
Okay, go ahead.
I think if it is a voidable contract like minor, when a minor enter into a contract with an adult, and the minor perform his part, and the adult does not perform his part, you can go for this doctrine.
Which doctrine?
Specific.
Specific performance, you mean? Not really, no. Not really. Yes, Tijani, your hand is up. Okay, let's move on.
Thank you for the opportunity.
Okay. Yes.
The remedy of specific performance would be granted where damages wouldn't be adequate to compensate the aggrieved party or the party in affected party to restore that party into the position he was before the breach of contract.
Okay. All right. Thank
you, my lord.
Thank you. Emmanuel Mensah.
Good evening, my lord.
Good evening.
The grant of specific performance, the court may decide to grant specific performance as a remedy where the monetary damage, as we understood from the previous lessons, may not be sufficient to compensate probably the injured party. That is one of the grounds. And also, there are times where the subject matter of the contract may be specific, involving, say, a parcel of land. So in such situation, the remedies that the court may grant to the injured party may not be payment of a monetary damage, but would rather be a directive on the remedy of a specific performance to, to that injured party. So that specific land, which is the subject matter of the contract, that is where the court may grant the same in its decisions.
Right. Thank you very much. Thank you. I mean, these are good responses. So let's move on. Other questions. So, yes. So we expect you to provide definition and the nature of specific performance. So specific performance, as we notice, is an equitable remedy, compelling actual performance of the contractual obligation. Again, it is not a right. If we say it is not a right, it's not something that you can demand as a matter of course. It is discretionary. It's discretionary. And being discretionary, we've noted that it's subject to all the principles of equity, the margins of equity that we know. He who comes with equity must come with clean hands. If you're looking at specific performance, I explained in our previous lessons that if you are looking for a decree of specific performance, then there should be no evidence that you prevented the other party from performing. For example, when you go to discharge by performance, one of the exceptions is where you have prevented the other party from performing. So in the same vein, if you are looking for a decree of specific performance, then it must not be the case that you prevented the contract breaker from carrying out his or her contractual obligation. So, as you rightly said, specific performance will be available when damages are inadequate, meaning that, because we say that equity follows the law. So where the law is giving fairness and adequate justice, equity will not come and supplement. So where monetary compensation or damages will be enough, specific performance will not be decreed. But where it will be inadequate, then it will be decreed. So as he rightly said, instances when it will be granted include contract for sale of land. As we know, land is unique because of location. If you are talking to real estate agents or property land economy experts, they say that location. The location of a land determines a lot about the land. And that is why if there's a contract to buy Blackacre C and the other party default, it's not enough for him to pay money. They'll go and buy Blackacre D because the location makes a lot of difference. So we cited the case of Redco against Sapon, if you remember the last time. And again, where it is not landed property, but maybe like movable goods. And what is involved? They are unique goods, like rare items which you cannot easily purchase on the market, artwork and other things. Then specific performance will be granted, as it were. Yeah, so we talk about the specific goods under the sale of goods contract, goods which have been identified and agreed upon before the contract of sale is concluded. So those are the specific goods. And that being the case, if you don't perform, specific performance will be decreed, particularly when the other principles are satisfied. Or if you are dealing with ascertained goods as opposed to unascertained goods, where you have gone through the process of earmarking, the process of setting apart from the whole lot so that we know the actual goods to which are referable to the particular contract. Then, subject to other principles being certified, specific performance will also be decreed in that respect. So let us keep that in mind. When will it be refused? Maybe the reverse of all that we talk about, where damages are adequate, such as maybe ordinary commercial goods that if you are giving enough compensation, you can get on the market, then it will be refused. Contract for personal services. No court will compel anybody to perform a service against his or her will. So when it comes to employment contract, apprenticeship, like maybe the Francisco and Barnum type of situation, no court of law will grant specific performance. Again, no court of law will grant another equitable remedy like specific performance which require constant supervision, a court will not grant that. Or where there will be hardship, that the balance of convenience tilt against it, including the clean hands doctrine not being satisfied, then it will not be granted. Then somebody started attempting to answer the question when I invited you. The person appeared to have been in error, but not strictly so, just because of how he or she started. Okay, what he stated is not completely wrong, but he came out in a very, if you like, in a wrong way. But there's some truth in what he was saying, and this is where we come to lack of mutuality. I mean, the point he was trying to make that if a minor and an adult enter into contract, he was just trying to about the fact that where the principle of mutuality cannot be satisfied, then specific performance will not be granted. So specific performance must be available to both parties. In other words, if A is taking it against B, the court will ask it, assuming being the other way around, could B have requested it against A? So that is how it went. And this is where the minor and the adult, analogy, our first contributor sought to allude to becomes relevant. Yeah, so when you have finished working through that, the question said that, are the principles sensible, or are they like fair principles? So that's where the evaluation becomes important. So the principles which govern the award or the grant of specific performance is sensible in the sense of balancing certainty of performance against practicality of enforcement. So certain types of contract, like as we said, rare commodities or land, certainly certain performance ensure that once the contract has been concluded, definitely there will be performance, and the courts will use this mechanism to do that. Another thing is also practicality of enforcement. As we have seen, where it will require constant supervision of the court, it will not be granted. Or where the circumstances are said that the contract should be performed as made, then this decree enables that to be done. So again, it prevents the court from micromanaging for like a business relationship as it were. Because when it comes to award of damages, there's a lot of should I say, the court trying to second guess what makes business sense for the parties. But then if you're being made to perform exactly what you contracted to do, then the original obligations are adhered to and upheld, rather than trying to translate it into money terms by way of assessment of what of damages. Of course, because it's discretionary and human beings are those who man the courts, sometimes the discretion may not properly be exercised as it were. So we are also bound to see some inconsistent outcomes as it were. So these are some of the things that we must have in mind when we are dealing with the question which was asked that how do the court decide whether to grant another specific performance? Are the criteria used sensible? Now let me make this point that assuming you go to your law school entrance examination, all right, and you are given, let's say, a two-part question. If I say two-part question, so let's say that under contract, you're given a two-part question. Maybe A is an essay and B is a problem-based question. Or A is a problem-based and then B is an essay. Certainly, the question I ask you to answer is just question 2. So question 2, it has two parts, A and B. Now, when you answer one part and you leave the rest, you should know that you have made a big mistake, because the marking scheme will definitely have different marks allocation for the two parts. So if you answered only the essay and left the problem, you're in trouble. If you answered only the problem and left the essay, you're in trouble. So you have to answer all aspects of the question. Please keep that in mind. So let's go to a problem part, okay? So I want you to look at this problem. Papaya Limited is a printing business. It makes a contract with Kwame Limited to repair one of its printing machines at a cost of 2,000 cedis. Kwame's employees negligently reassemble the machine incorrectly, so that the first time it is used, a drive shaft breaks and the machine is then beyond repair. The cost of replacing it is 75,000 cedis. And Papaya Limited is unable to obtain a replacement for 3 weeks. During this period, it is estimated that the lack of the machine has reduced the firm's profits by 5,000 cedis per week. Moreover, the firm misses out on the chance to bid for a very lucrative contract, which will have produced a profit of 60,000 cedis. Advise Papaya Limited as to the damages they can claim for Kwame Limited's breach of contract. Yes, so I want you to 2 minutes, just try your hands on it, and then I want somebody to lead us to discuss it quickly. And all the time, be mindful of the IRAC. Will anybody have a shot? Give it a try. Anybody? Okay, if you are not talking, I'll continue. The question is pretty straightforward. So, anybody? Okay, so you must have introduction, okay? And then the introduction should address one or two main things. If you are the type who would like to study the area of law, okay, so you study the area of law. So the area of law is remedies for breach of contract, or the question was direct. It said damages for breach of contract. So when a contract is breached, the innocent party is entitled to damages aimed at protecting the expectation interest. That is, to be placed in the same position as if the contract had been performed, Robinson and Harman. So the issues which arise from the question include the following: whether Papaya Limited can recover the cost of replacing the machine. 2, whether Papaya Limited can recover 3 weeks lost profits. 3, whether Papaya Limited can recover the lost lucrative contract of 60,000 cedis. And then 4, whether mitigation and remoteness rules limit recovery, if you like. So these are some of the issues you may raise. As I said, for me, I prefer you taking the issue one after the other, okay? So whether Papaya Limited can recover the loss of replacing the machine, which is the same as recovery of the recovery of the replacement cost. It's the same thing here. So that is the issue 1. Okay. Now, because I am teaching, I have written this principle of law, application, analysis, conclusion. Okay, just for purposes of teaching. But personally, I don't think that you actually need to write principle of law. You can just state the principles of law, and then you do the application. You start, and then you do your application analysis without even writing application analysis. You just do it, and you have your conclusion. But because there's a problem we have in Ghana, and that problem has to be appreciated as we are helping you to revise for the entrance examination, because we have different law faculties, okay? We have different teachers teaching the common law subjects like law of contract, law of tort. It becomes difficult to be very uniform. So when it comes to making marking scheme for this type of examination, in terms of formalities, there's a bit of like flexibility. So the focus is on the substance. If you wrote, let's say, of course, the starting, you need to do what we said. You need to list all the issues, okay? Because in the marking scheme, there'll be marks allotted for that. So the issues arising from the problem are the following. You list them, okay? And then you come and take the issue one after the other, and each of them, principles of law. If you write principle of law, there's nothing wrong, except that, there's nothing wrong, as I said, because of lack of uniformity. Some people are comfortable with it. Other people, like myself, are not comfortable with it. But as I said, your examiners will accommodate some of these minor differences in stylistics or formalities. So don't be bothered about that. Just focus on the substance. So you have the issue whether Papaya Limited can recover the cost of replacing the machine. And if you look at the story, the recovery of the replacement cost is 75,000 cedis. Can it be recovered? Tell us the law. Expectation damages recover pecuniary loss caused by breach. Innocent party is entitled to the difference between contractor performance and what was received. Robinson and Harman cases like Muller and Home Finance, you mentioned them. So you stated the principles or the law. So you attempt to do the application and analysis. So Papaya contracted for a repaired usable machine at 2,000. Instead, machine was destroyed due to negligent reassemble. So the only way to restore Papaya is to provide funds for a new machine. And then the replacement cost, according to the fact, is 75,000 cedis. So it's directly attributable to the breach, because having regard to the outcome, the fact that the machine is destroyed, there's no way that he can get like the machine back unless you get a new machine. If you look at this case, we don't have serious problem with issues of remoteness or foreseeable that negligent repair could destroy machine. This arise naturally. So the problem of what we have in maybe the second limb of the rule in Hadley and Baxendale, as explained by Ascuf LJ in New Victoria, Landry, like as whether no actual knowledge, imputed knowledge, and so on were shared at the time of making the contract. They are not important in this type of case because it's pretty straightforward. So the conclusion on that issue is that Papaya can recover 75,000 as a replacement cost. And go to another issue. So the next issue is whether Papaya can recover 3 weeks lost profits. So that's like the next issue, recovery of lost profits for 3 weeks. And if you look at the facts, it's 115,000. So you tell us like the principle. Loss of profits recoverable as normal expectation loss if foreseeable. So if foreseeable here, we are talking about if at the time of making the contract breaker have been given information as I explained, whether he had an actual knowledge of the particular, if you like, the contract which they were supposed to have met, so that if there was a delay or there was anything preventing them from getting the machine and they will not be able to do that business, then whatever money that could be made from it will definitely be lost. So as happened in the Hadley and Baxendale and then Heron 2. So Hadley and Baxendale tells us damages cover losses arising naturally or within contemplation of both parties. Heron 2, that there's a stricter foreseeability in contract that the loss must be a serious possibility. Of course, attempt was made to try and draw some fine distinction between this and two, but that's also really important. The most important thing, going back to Newman, Victoria and Newman industry, that it will depend so much upon the knowledge or the information which was made available to the other party regarding, let me say, the business or the other contract which was expected to be performed by the innocent party if the contract breaker had not actually break the original contract. So let us keep that in mind. So when you have outlined the principle like that, then you do the application. Kwame knew Papaya was a printing business, rely on the machine for daily operations. So it was foreseeable that defective repair will stop production. In other words, it could be anticipated or contemplated that if there had been a problem in getting the machine fixed according to the agreed time, they're going to be out of business and there will be business interruption, and whatever profits which will have been made during the period that they had run will definitely be lost. So if we look at the facts, 5,000 cedis was actually lost per week for 3 weeks, and that's about 15,000 cedis. And that will be considered as a direct or natural consequence because as a printing business, it runs business every day. So if there's a contract for you to fix a broken machine and you are negligent or you don't fix it well, for whatever period that you have not been able to get it according to the agreed contract, they are going to be out of business, and whatever revenue which will have been made during the period will be lost. So if we look at the facts, that will come to about 15,000, and that is considered as a direct or natural consequence. So clearly, within contemplation of both parties at the time of contract, that amount had actually been lost, and Papaya can recover the 15,000 cedis as a lost profit. Then you take another issue. So what I am interested in is that you being systematic, okay? If you are systematic, you'll be able to cover most of the issue which need to be covered so that you don't lose any marks or points under the marking scheme. So the third one, I think, has to do with the, as we said, whether Papaya can recover the lost lucrative contract of 60,000. Can that lucrative contract Papaya limit printing press could actually not meet because of the defective repair of the machine? Can that be attributed to the breach? So that is the crux of that issue. So you have to outline the principles that damages are not recoverable if too remote. In other words, if it does not arise naturally from the breach of the contract or it doesn't come within the exception that it was within the reasonable contemplation based upon the knowledge or the information which has been shared at the time the contract was made. So Hadley and Baxendale tells us that damages are only recoverable if within reasonable contemplation of both parties. Then Victoria Laundry against Human will clarify that ordinary profits are recoverable, but exceptional profits, such as special lucrative contracts, are not recoverable unless defendant had what? Knowledge, as we'll be saying. So you've stated the principle, you come to the application and the analysis to see how the hierarchy is working beautifully. So application analysis, Kwame likely knew that Papa here rely on the machine for general printing business, but not that Papa here had a specific 60,000 cedis contract opportunity. If you look at let's go back to the facts. If you go back to the facts, let's look at the facts. Nothing in the facts actually tell us, Papa is a printing business, this contract with Kwame to repair one of his printing machine at the cost of 2,000 cedis. Kwame and police negligently reassembled the machine incorrectly, so that the first time it is used, a drive shaft breaks and the machine is then beyond repair. Then there's a cost of replacing 75,000. Papa Limited was unable to obtain a replacement for 3 weeks. So during this period, it is estimated that the lack of the machine has reduced the firm's profit by 5,000 cedis per week. Moreover, the firm misses out on the chance to bid for a very lucrative contract, which will have produced a profit of 60,000. Now, from this story, nothing in this story, okay, points to the fact that the contract breaker, that is Kwame Limited, actually knew about this lucrative contract. Nothing shows that it had information that there was a particular special contract which this papaya printing press was supposed to also deliver on. However, from the everyday operational revenue, that one, it arises naturally, and so that can be recovered. But the special, the lucrative profit cannot, as the information we have told, there's no information which shows that the Kwame Limited actually knew about this special contract. So unless Papaya informed Kwame of this special contract, it falls under abnormal loss, or what you call special damages in the Hadley second limb of the rule. So it will not be recoverable. It will only be recoverable where there was information. But in this case, there's no evidence that Kwame Limited knew that Papaya Printing Limited had a special contract to also deliver. So, in the final analysis, the 60,000 contract resembles Victoria Landry's lost lucrative dyeing contract. So that proof Kwame knew about this, or that proof that Kwame knew about this opportunity, the claim is so remote and cannot be recovered. So here, you see how in the application and analysis, we are still able to weave the applicable case law into the discussion. So that is how it is done. So in conclusion, Papaya cannot recover the 60,000 cedis unless it proves Kwame had knowledge of the contract. Then we are done with that. Then we come on to the last, and then the fourth issue relating to mitigation of loss. We know the principle. The principle is basically that the claimant must take reasonable steps to minimize losses. Cases like British Westinghouse against Underground Railways emphasize that principle, that an innocent party or a claimant or a plaintiff cannot recover avoidable loss. So that is losses that you could have used reasonable steps to actually minimize. In this particular case, Papaya attempted to obtain a replacement machine, but could not for 3 weeks. So, if you look at the facts, there were no alternative means available. It's not the case that when the machine broke down due to the negligent reassemble by Kwame staff, Papaya did not do anything. The facts indicate that they attempted to get a replacement, but they needed to wait for 3 weeks before that could be available. So in that regard, Papaya Limited acted reasonably and cannot be said to have breached the doctrine of mitigation of damages. So there's no failure to mitigate, and no deduction can be made from the damages which are to be awarded in favor of Papaya Limited. Then you come to overall conclusion, okay? So when you have finished everything, you pull everything together, have the overall conclusion. So overall conclusion is that Papaya Limited can recover the 75,000 cedis as replacement costs and 15,000 cedis as lost profits for 3 ways. The additional claim for 60,000 cedis lucrative contract will likely fail unless Papaya proves Kwame knew about it. So the total likely recovery damages will be this. So that is how we go about solving problem-based question. Is there any question on this before we move on?
Respectfully, I want to ask, so will we write the overall conclusion before we answer?
Yeah, so you have, you may not add the word conclusion, but you can just write in bold because the rest, you'll not be writing like the small conclusion as you move along. So you have like the introduction and you have like the final, if you like, conclusion, isn't it? These ones, the small conclusion here, they're actually part of what you'll be doing. And I will say that when we are discussing each issue, let it stand out as like as a subsection. And then under the issue, you state the principles, you do the application analysis, you conclude on it, and then you leave a line or two. Take another issue and you do that. Then when you have finished everything, then you can just write a conclusion. Even the final conclusion, you can write the conclusion if you like, even in capital, for you to stand out that that's the overall conclusion. And then you let us know and then you move on. I don't know if that answers your question. Okay, so let's look at question 3. In awarding damages for breach of contract, the courts are concerned only with financial loss. They will never compensate for mental distress or other non-financial loss. Discuss. This is a very pretty straightforward question, and I will not belabor the point. The reason being that what we discussed initially and in question 1 can be adapted, okay, to answer this question. So I will not belabor this particular one. I just move on to another one. It is clear that in any civilized system of law, is bound to provide. It is clear that any civilized system of law is bound to provide remedies for what has been called unjust enrichment or unjust benefit. That is, to prevent a man from retaining the money of or some benefit derived from another which it is against his conscience he should keep. Now, Lord Wright made the statement in the well-known the Fibrosa case, the case that we cite when we are discussing frustration. So how does Ghanaian law attempt to provide such remedies? Lord Wright made the observation in Fibrosa case, okay, that in any civilized legal system, you cannot allow someone to unjustly enrich himself or unjustly benefit at the expense of another. It's against conscience, and remedy should be provided against that. So question is, how is that done under our law? And is it done in a very satisfactory manner? Okay, so in every essay question, you should be structured in your approach. You must have your introduction. So you state like the general rule, as we'll be discussing, that damages in contract are compensatory, not punitive. And the primary aim is to protect the expectation interest, as we'll be discussing. So all the things I will be saying. And then traditionally, these have been limited to pecuniary or financial loss. but not to distress or hurt feelings, as the case of Addis against Gramophone Company actually noted. But the statement is too absolute. There are established exceptions. So you talk about the financial loss. We've noted that the courts are reluctant to provide compensation for non-financial loss. That is the general position, but we have an exception. And the general position is supported by the case of Addis against the Gramophone Company Limited. In that case, the court refused to award damages for harsh manner of dismissal. Because the person was complaining that, having regard to the contract of employment, how he was dismissed was really harsh, and the court should award compensation. And the court said no, because contract law is not designed to compensate for motions. It is rather tort law which covers such matters. Then, but the exceptions, what are the exceptions to the general rule that the court will not award non-pecuniary damages? One exception is when it comes to contract for pleasure, enjoyment, or peace of mind. So where the object of the contract is to provide enjoyment or realization, okay, like the holiday package that we mentioned, damages may include disappointment or distress, like the Jarvis against the Swan Tour, which will be mentioned, and then Jackson against Horizon Holiday. Over day two, the court was even prepared to extend monetary compensation for other distress, which family members within the holiday package had also suffered. Then loss of amenity, what we call consumer surplus. I explained the Rosy Electronics that non-pecuniary damages are recognized where claimant is deprived of enjoyment value, even if it's non-measurable financial loss. Maybe what the person has actually lost under the contract cannot easily be quantified in strict money terms, but the court will be able to award something in order to vindicate that particular loss. As I said, the Rosy Electronics, the person contracted for swimming pool of a specific dimension. They did it, but they didn't deliver the swimming pool according to the strict dimension. There was a bit of like a shortfall. Regardless of that, the swimming pool made was as efficient, effective for any swimming pool, including if they had made it according to the original specification. It could be used for diving, it could be used for anything. That notwithstanding, the court was prepared to agree with Mr. Fawcett that once he had not obtained a swimming pool of the exact specification that he had contracted for, he had experienced or suffered we call diminishing in value. And so a certain intrinsic excitement, which you have had from having a swimming pool of a particular specification, that was not done. So damages was awarded for loss of what? Amenity. So the point is, the law recognizes subjective satisfaction in performance in that respect, or what economists will call consumer surplus. Again, contracts protecting against distress or anxiety, where the purpose of the contract is to prevent worry or embarrassment. Damages may be awarded if it fails. For example, if you look at the case of Haywood against the Whalers, someone actually engaged solicitors to obtain an injunction to prevent some harassment from being done to him by other people, and the solicitors failed to obtain the injunction. So he later sued the solicitors to recover compensation for the anxiety which he had been through. Because if the injunction had been obtained against them, they wouldn't have succeeded in being able to go ahead with threatening harassment, as it were. Yeah, so I would say that our law follows the English approach. And I have mentioned our Jason Smith against KLM Dutch Airlines. The gentleman who was to travel to attend Belgium or so for business contract signing, and due to some difficulties, KLM could not fly him according to the agreed ticket. And he sought to sue them to recover for so many things, including even the profit he would have made from the contract he was going to sign, which he couldn't get there to sign. Hotel bill that he has to do, new ticket arrangements and other things. Well, the court disagreed that he could not get, everything he was asking for, but that he could get damages for inconvenience and some discomfort suffered, as it were. So, in that respect, we say that our limited case law available in this particular area of awarding damages show that the court is prepared to grant damages for inconvenience in certain aspect of breach of contract. Okay, so when you finish, you just pull everything together and then you draw your conclusion, and that every essay question must have a conclusion as it were. So the statement which was made earlier on that the court will not award non-pecuniary damages is not completely accurate, because we have seen the general rule that yes, the general rule is that damage concerns financial loss, but the exceptions. An exception, the courts are prepared to award damages for some non-pecuniary loss, including contracts whose subject is enjoyment, like holiday contract leisure, where the claimant or the plaintiff suffer loss of amenity, like raising electronics and faucet, or the contract protests against distress or anxiety, like the Willis case, and then of course our own Jason Smith. So these are some of the things that you need to pay attention to. Now the fibrosa case, because we'll be discussing what we call discharge by frustration. When I'm discussing that I discussed that with you, so I have skipped the unjust enrichment, because what is actually done under section 1, subsection 2, and subsection 3 of the Contract Act 1925 is practical application of the unjust enrichment doctrine when there has been a breach, when there has been a frustration of contract. Because as you remember, we're not discussing that, but just as a footnote remarks, where there has been frustration, what it means is that the parties cannot continue to perform the contract as originally designed, all right, due to the supervening events. However, it may well be that one party has, for example, paid money under the contract before becoming frustrated, or has actually incurred some expenses towards performance of the contract, which has become frustrated. And then the other party has even probably benefited somehow from the initial expenditure incurred by the other party trying to perform. So when there has been frustration, despite the fact that the parties are released from their strict original contractual obligation, in order to ensure fairness, our lawmakers within the context of the Contract Act, section 1, subsection 2 and 3 says that the court should have regard to the circumstances and make the necessary determination, which will be just, so as to ensure that no party is actually, if you like, treated unfairly, having regard to the circumstances which have actually occurred. So that is a practical application of the unjust enrichment principle, which we alluded to in the question above. But we'll come back to that. So let's take one more problem-based question before we be getting ready to sign off for tonight, and then tomorrow we do a couple of sessions. So look at this question. In January 2022, Kumasi University acquired a large site containing a derelict warehouse on which it proposed to build a new hall of residence. In connection with this project, it took the following steps. A, it engaged a firm of architects, Owusu & Co., to draw up plans for the new building. The contract price was to be 120,000 cedis with a deposit of 75% payable immediately. Kwame, the university's finance officer, incorrectly calculated the deposit as 18,000 instead of 9,000 and paid the larger amount to Owusu. So look at the story well. It offered the job of clearing the site to tender. The lowest tender was 280,000 Ghana cedis, was received from Mensa & Co. The university decided to contract with it. Negotiation on the details of the contract were slow, but in the meantime, the university allowed Mensa onto the site to start work. And C, it brought 20,000. Maybe let me reduce the distance so that if you want to see the full, you're able to see it. Okay. So it brought 20,000 used blocks from Ado Limited at a price of 200,000 cedis. Several hundred of the blocks were used immediately to repair buildings on the university main site. The rest were to be used for the warden's accommodation at the new hall. In June 2022, Owusu & Co., whose business was in difficulties, terminated its contract with the university, having produced only an outline sketch of the hall. Mensa's work was proceeding so slowly, though 20% of the site had been cleared, that the university told it to leave the site as it was going to offer the clearance contract to another firm. Finally, the blocks turned out to have been stolen, though Ado Limited was ignorant of this and were reclaimed by the true owner. And the market price of such blocks is now 8 cedis per block. I hope you are following the story. I will copy this problem and put it on your WhatsApp platform so the thing to discuss, that's the question. So maybe let me put it on your WhatsApp platform just in a minute. So I'll put it on your WhatsApp platform too. So just look at it in a minute and let's discuss. Yeah, I'm sure you've had a look. Okay, so anybody lead us to discuss it? Anybody? Yes. Yes, who is leading us? Anybody? Are we together? Okay, since you are not talking, let me just speak to you and then I'll get out of here to do some other things. I'll put the question on the WhatsApp platform, most of you who are there. So nobody talking. Okay. Just, you are not talking now. You will talk on the exams day by yourself. Okay. That's good. Good. So the program raises the issue of restitution and unjust enrichment, where we've had like a contract, a breakdown, or somebody defaults. So key issues which we may raise in a question like this. Well, we see the excess payment made to the architects, also and co, and also some payment have been made for the work done by Mensa and Code, like the site clearance. And there's also an issue as to whether there can be a recovery or some liability can be fixed regarding the stolen blocks purchased from Ado Limited. And the law here, as I say about the principle of restitution, which is to prevent unjust enrichment, where one party benefits from failure at another's expense. So, restitution allows recovery of money paid by mistake, what we call the money had and received. So where money has been paid by mistake, or someone has had the money paid to him, and the money, for example, cannot be recovered under contract because it's illegal or because it's frustrated or the contract vitiated by mistake, as it were. The money can be recovered by as a money had and received. So as Fibrosa case reminds us, the money paid under failed contract is recoverable for total failure of what? Of consideration. So in this particular case, if you look at the story, the agreed deposit was the agreed deposit was 7.5% of 120,000. And if you do the computation, then it comes roughly to 9,000 cedis. But as a result of a mistake, 18,000 cedis was paid. Okay. So there was an excess of 9,000. Instead of paying 9,000, it was paid, if you like, twice. And the architects terminated early. And if you look at the story, they had produced only sketch. Well, one will argue that that is not much. So, and for that matter, because they have done only relatively a small fraction of the work involved, okay, it's just negligible. The university can recover the excess of the 9,000 cedis and money had and received, what we call like a restitution for mistake. Or you can also even come under total failure of, if you like, a consideration, except that here we're not talking about, if you like, a frustrated contract. So the things under section 1 are not necessarily directly applicable. That is not what you're talking about. So if also the company also argues partial performance, that they had partially performed, the court could find maybe minimal benefits. And it's just a question of how you discuss whether it is unjust for them to retain the excess of the money, 9,000 or what. Of course, when we discuss, and this is also not a question of the doctrine of substantial performance and discharge of performance. No, that is not what we are talking about. So, in the final analysis, the university can claim the excess of the 9,000 cedis paid in a mistake, and that we under money had and received as a restitutionary claim. In a question like this, it just the facts are a bit intimidating, but it's not that difficult. Just require you to apply your cool head to basic principles, and you'll be able to work your way around. So when you see certain set of facts or configuration of facts, don't get intimidated, okay? And start panicking. Just be calm and be able to work your way around it. With respect to the payment which was made for Mensa and Co. regarding the site clearance, the principle of law includes the fact that where a contract is not completely carried out or repudiated, there may be a claim on basis of quantum merit. That is, reasonable payment may be made for as much as the performance standard is worth, reasonable value of the work done, or what in construction they call the pro rata, if you like. Payment may be made on basis of quantum merit or pro rata basis. Remember the case of a plant against a Coben, where the claimant was able to recover for part performance when the contract was abandoned. So, Mensa cleared about 25 or quarter of the site before they were dismissed, if you like, from the site, despite the fact that they had not fully completed the work, university allowed them to be on the site and accepted the benefit of the quota performance 25%. It would therefore be unjust for the university to hold on to the benefit without paying them for what they have done. So Mensa is entitled to reasonable remuneration for the benefit conferred. That is 25% of the agreed. And maybe if the university wants to claim for delay and inefficiency by way of undergrad, that's a different matter. Recently, we decided the case at the Court of Appeal, the case of the ceremony against Olam Limited, and it's somewhere along a similar pattern of facts. What about the recovery of money paid for the stolen blocks? Well, maybe you may have to fall on your ideas from a little bit of general sale of goods. Like a buyer does not obtain title to selling goods, as you know, even if purchased in good faith. If Nemo that could not have it, one cannot give what one does not have. If you buy something from someone who doesn't have a title, you cannot get a title, despite the fact that you did it in good faith. You can only get the title where his title has not been avoided, in which case you can have the title. And we know under the sale of goods, the seller must have the right to sell. So let's keep that in mind. So the university paid 200,000 for the 20,000 blocks, and several hundred blocks had already been used. So in that case, there have been, if you like, a partial consideration, not total failure of consideration. Rest of the blocks could be reclaimed by the true owner. And if we look at the facts, we are told that the market price now is 8 cedis per block. So the university, if you do the computation, okay, the university cannot get replacement at the same cost because the unit price has changed. So for blocks lost to the true owner, there have been total failure of consideration. The university can recover the corresponding proportion from Ado Limited. But the blocks which have already been used, the benefit has been retained by the university. And for that matter, there's no possibility of restitution. So the university may also claim damages for the difference between the contract price, which was 10 cedis per block, and the current market price, which is 8 cedis per block. If, for example, he framed the claim under the Sale of Goods Act at 137. So, in conclusion, with respect to that sub-issue, the university can recover proportion of the 200,000 cedis relating to the stolen blocks, not retained, but must bear cost of blocks already used because of the principle of what? Unjust enrichment. So overall, that is when everything is pulled together. The final conclusion is that the university has the following remedies. With respect to the architect, Osu and Co., it can recover 9,000 cedis, being the overpayment due to mistake and failure of consideration. With respect to the site clearance by Mensa and Co., it is liable to pay them reasonable amount on basis of a quantum merit or pro rata for the work done. Of course, if they want to make any deduction for the delay, that can be looked at on its own terms. And then the blocks, it can recover money for the stolen blocks, not retained, but cannot recover for blocks already used. So these are some of the issues and how they are resolved. And that's our final conclusion. But the takeaway is that when you get any hypothetical or any fact-pattern question, pay attention to the facts. Don't be scared by the seeming complexity of the facts, okay, and panic. Remain calm. If you have to read the scenario 2 times or 3 times, do that so that you're able to see your way clear. Okay, so we will draw the curtain here tonight and come back tomorrow. We thank God for how far we've come. Gracious Lord, we are grateful for the time spent in learning together. May the lessons gained tonight remain in our hearts and minds, strengthen us for the work ahead, calm our anxieties, and guide us to recall with accuracy what we have studied. May all our efforts bear fruit to your glory and the service of justice and humanity. Amen. Have a good night, and tomorrow when I come online, I'll give you a signal if you want to join. That is fine.